Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to the Employee Survival Guide, produced by employment attorney Mark Carey.
Thanks for having me back.
Yeah, of course. So, when you picture a modern manufacturing plant, you probably imagine this incredibly synchronized machine, right?
Oh, for sure. Conveyor belts humming, everyone moving in perfect harmony.
Exactly. It's supposed to be this place of just, pure calculated efficiency.
Right, because that blueprint is the absolute goal.
Yeah.
I mean, the whole business model relies on predictability to keep the assembly line moving.
But what happens when that synchronized system just completely breaks down? And I don't mean the literal machines, I mean the human machinery.
Yeah, the people.
Right. What happens when the factory floor devolves into this battleground of cultural misunderstandings and, alleged retaliation?
And some incredibly high-stakes legal maneuvering.
Exactly. So today we are looking at a fascinating federal lawsuit. It was filed in the District of Connecticut.
Right. This is the case of Tevin Cagle and Gerald Robinson versus Duro-Helix Poly LLC.
Yeah, and our mission here is to really just tear this dispute down to the studs. We're looking at two foundational legal documents, which, set the stage for everything in a federal courtroom.
The pleadings, yeah.
Right. First, we have the plaintiff's amended complaint, which lays out their grievances. And second, the defendant's answer and affirmative defenses.
Which the company's very formal, aggressive pushback.
It really is. Now, for you listening at home, whether you're an employee navigating workplace friction or maybe a manager handling diverse teams, this case is an absolute masterclass.
It really is a masterclass in how facts form the foundation of a court's eventual holding. But it's crucial to remember that we are dealing with two entirely opposing narratives here.
Right, completely opposing.
Yeah, I mean, the plaintiff's complaint is all allegations. It's their version of events.
And the defendant's answer.
That's their legal defense. They admit, minor facts like employment dates, but they vehemently deny the core allegations.
So we are staying strictly neutral today. We're just looking at the mechanics of this dispute. Okay, so let's set the stage. We're at a Duro Hilex Poly, or DHP, plant in Meriden, Connecticut.
Right. And the setting is everything here. A factory floor is not a quiet corporate office.
Oh, definitely not. It's loud, it's fast. So let's introduce the plaintiffs. First, we have Tevin Cagle, hired around August or September of 2021 as a packer.
Which is an entry-level role.
Right. And he eventually gets promoted to machine operator. Then we have Gerald Robinson, hired in November 2021, same trajectory.
Yep.
Now, both Cagle and Robinson are Black. Cagle is of Jamaican heritage. And crucially, he has a severe visual impairment.
And that visual impairment is going to be the cornerstone of a major disability discrimination claim later.
Right. So they're working the third shift, the night shift.
Which is always a different atmosphere. Supervision is lighter. The isolation is, a lot more pronounced.
And the plaintiffs allege they were the only two Black employees on that night shift for most of their tenure.
Yeah, and the demographic landscape they step into is really specific.
Right. The complaint says the majority of the workforce was of Indian national origin or heritage, speaking Gujarati or Hindi, along with some Hispanic employees.
And the management structure is detailed meticulously. You've got Kalpesh, the shift lead, David Senior, the night shift supervisor.
Then Richard Bolognese, the production manager, Ravi, the plant manager, and Christine Kortzenko in HR.
Laying out that chain of command is a deliberate legal strategy. They're mapping out who had authority and who allegedly failed to act.
And they don't just say they were the only Black employees. They allege that other Black employees had previously quit due to discrimination.
Which is a massive allegation to throw into a federal complaint.
I mean, yeah. How does a company even defend against that?
Well, DHP's answer handles it firmly. They flatly deny that Cagle and Robinson were the only Black employees, and they categorically deny that anyone quit due to discrimination.
So they're putting the burden of proof on the plaintiffs.
Precisely. If the plaintiffs can't produce those former employees or HR records in discovery, that claim vanishes.
Okay. Let's unpack this workplace dynamic. Imagine moving to a new country and being the only person who doesn't speak the local dialect, but you're in a dangerous manufacturing setting.
That's incredibly isolating.
Right. But my question is a workplace inherently hostile just because the majority of coworkers speak a language you don't understand?
What's fascinating here is how the courts look at this exact nuance. The short answer is no. Speaking a native language isn't illegal.
Okay.
The law doesn't mandate English-only rules unless there's a strict business necessity, like emergency safety communications.
So it's about the weaponization of the language.
Exactly. Casual chatting in Gujarati in the break room. Totally legal. But if that language barrier is intentionally used to exclude someone based on race or refuse them training, that crosses a massive legal line.
And that isolation leads directly to the first tangible impact on the plaintiffs. Let's talk about the missing raise.
Right. Robinson's wage claim.
He alleges he was promised a raise from $18 an hour to $19.75 after 2 months of training.
But he never got it.
Never got it. And he alleges that non-Black operators did get it.
Classic disparate treatment claim. But look at DHP's answer. They don't just say no. They state they are, quote, without knowledge or information sufficient to admit or deny what other non-Black operators were paid.
Wait, really? How does a corporation not know what they pay their own people?
I know it sounds absurd, but legally, it's a tactical maneuver. They're saying the allegation is too vague, so they deny it until the plaintiffs get specific in discovery.
Wow. Okay, so while Robinson is fighting for his wages, Cagle is dealing with the training side.
And this is where the language barrier issue explodes.
Right. Cagle is being trained by Narendra. And Cagle claims Narendra outright refused to speak English, only using Gujarati, Hindi, and hand gestures to explain heavy industrial equipment.
Which is a profound safety risk.
Oh, absolutely. And Cagle says he didn't even know Narendra could speak English until months later when he overheard him talking perfectly fine to his supervisor.
But DHP's defense here is strategically fascinating. They admit Narendra used hand gestures and Hindi, but they claim he genuinely struggles to speak English well.
Oh, so they're framing it as just a practical barrier.
Exactly. Not a malicious, discriminatory act, just a lack of vocabulary.
But then you add Cagle's visual impairment to this. It's like asking someone to fly a plane blindfolded and then refusing to tell them where the buttons are.
It's a huge issue.
Cagle alleges he asked the shift lead, Kalpesh, to slow down machine repairs so he could actually see them. But Kalpesh allegedly ignored him and just physically moved Cagle out of the way.
And that is the bedrock of Cagle's disability discrimination claim under the ADA. The court will eventually look at whether DHP made a good faith effort to provide a reasonable accommodation.
Shoving someone out of the way doesn't sound like a good faith effort.
No, it's the antithesis of the interactive process required by law. But of course, DHP denies these allegations in their answer.
Right. So all these issues are piling up. And in February 2022, management holds a meeting.
A sweeping meeting for all machine operators. Plant manager Ravi and HR are there.
And according to the complaint, management acknowledges they need to, quote, change the culture and break the pattern.
Which, if true, is a remarkable admission that they knew the culture was toxic.
But the plaintiffs say the meeting didn't fix the racism. Instead, management announces they're reducing shifts from 12 hours to 8 hours on a machine-by-machine basis.
Which is a catastrophic financial hit for a factory worker.
Right. And here's the retaliation claim. Plaintiffs allege only Cagle and Robinson had their shifts cut.
Wow.
Yeah, they claim all the other machinists kept working 12 hours. Plus, they allege their machines were being purposefully sabotaged by packers.
DHP's answer admits they announced the phased shift reduction, but they vehemently deny targeting the plaintiffs or that any sabotage happened.
But let's look at the timeline. If they announce a change for everyone, but allegedly only the two guys complaining get their hours cut, I mean, is that just a wild coincidence?
And that is the crux of counts 5 and 6, retaliation. If we connect this to the bigger picture, the legal standard requires proving a causal connection.
So they have to prove the complaints caused the pay cut.
Exactly. The timeline looks suspicious, which shifts the burden to the company to provide a legitimate business reason, like production schedules.
And then the plaintiffs have to prove that reason is just a pretext.
Right. A cover-up.
Okay, so while the hours are shrinking, the tension on the floor is just boiling over. This brings us to April 2022.
The physical intimidation incident.
Yes. Robinson and Kalpesh get into it. Kalpesh is like 6'4". Robinson alleges Kalpesh towered over him, poked him in the chest, yelled in Hindi, and used gestures meaning, "You're stupid."
Physical contact by a supervisor completely changes the liability landscape.
And how does management handle it? The plant manager, Ravi, sends Robinson, the guy who got poked, home for the day.
Right. And DHP admits Kalpesh is tall, admits there was a disagreement, and admits Robinson was sent home, but they deny the chest poking and the abusive gestures.
But the next day is where it gets really dark. Robinson complains to the production manager, Bolognese, and a coworker, known only as Jay, interrupts them.
Right in front of the supervisor.
Yes. Jay allegedly tells Robinson, You got to calm down. You're an angry black man.
Which is the introduction of a historically weaponized stereotype.
And it allegedly spreads. A month later, Cagle asks Jay for a minute while fixing a machine, and Jay uses the slur again. Here's where it gets really interesting to me.
Yeah.
How does a stereotype get weaponized like that? Once that label is applied, doesn't it trap the employee? I mean, if you get upset about being called an angry black man, you just quote-unquote prove their point.
It's a devastating psychological trap.
Yeah.
And legally, a hostile work environment claim hinges on management's knowledge.
So if the boss heard it...
If Bolognese heard it and did nothing, the company's directly liable. But DHP completely denies Bolognese ever heard it, and they claim they don't even know who Jay is.
Which sets up a massive factual showdown for the court.
Absolutely.
So this pervasive tension sets the stage for how discipline is handled. In August 2022, Robinson is terminated.
Allegedly for attendance.
Right, but Robinson claims he followed call-out procedures to care for his stepmother. He argues it was retaliation. He even contacts corporate HR, but says they didn't investigate properly.
DHP denies the failure to investigate, naturally.
But then you see these alleged double standards with Cagle, like the August 2022 safety meeting.
Oh, this is a prime example.
Yeah. A white employee named Scott leaves the safety quiz early. No discipline. But Cagle challenges the safety coordinator on an answer. They yell at each other. Cagle leaves, and HR threatens him with a 1-week unpaid suspension.
Cagle points out the disparate treatment right away.
Right. He's like, Scott left early and is fine. I leave and get suspended.
But DHP's answer states that Scott had prior explicit management approval to leave early.
Okay, so if Scott had a hall pass, maybe it wasn't a direct double standard in that moment. But it still feels like Cagle is operating under a microscope where every move is scrutinized.
This raises an important question about documentation and pretext. If Cagle is constantly threatened while others aren't, the court will heavily scrutinize corporate HR's role to see if the company acted fairly overall.
Which leads us right to October. A false complaint is made that Cagle didn't clean his machine. But Cagle wasn't even working that shift.
An impossible accusation.
Literally impossible. So he asks his supervisor, Signor, what he's going to do about these false accusations. And Signore allegedly swears at him and says, why does it fucking matter?
Which DHP claims they don't have enough info to admit or deny.
Right. But Cagle's frustration boils over. He needs a lifeline. And this leads to what I call the December ambush.
The breaking point.
Yes. Cagle sends multiple emails to HR, citing the company handbook's open door policy.
Which is designed to let employees bypass hostile direct supervisors.
Exactly. He wants a confidential meeting to discuss the disparate treatment and the lack of accommodation for his vision. And he explicitly requests that Bolognese and Signori not be there because they are the problem.
A completely reasonable request under that policy.
But on December 6th, Cagle arrives at the meeting. HR and the plant manager are there, and they brought Bolognese and Signore with them.
Unbelievable.
That is wild. It's like asking for a mediator to help with a dispute with your neighbor, and the mediator surprises you by bringing your neighbor to the meeting. How is that an open-door policy?
He walked into a tribunal of the exact people he was complaining about.
Right. So Cagle feels targeted. He's terrified of the angry black man stereotype being used against him if he gets upset, so he attempts to leave to de-escalate.
And HR threatens him with suspension if he leaves.
He walks out anyway.
Yeah.
And DHP suspends him for 1 week without pay for insubordination.
DHP's answer admits all of this. They admit who was there, and they admit suspending him because walking out of a meeting with management is insubordination.
But legally, how does a judge look at that?
The court will have to decide, was this standard managerial discipline, or was this a retaliatory setup? If HR engineered the situation to provoke him, the insubordination defense crumbles.
Wow, so they finally take this out of the factory. They go to the state.
Right, they file CHRO complaints in May 2023, get their release of jurisdiction in November, and file this federal lawsuit.
With 7 distinct counts.
Let's break those down.
Counts 1 and 2 are race discrimination. Counts 3 and 4 are color discrimination.
Which are legally distinct, by the way. Color discrimination is specifically about the pigmentation of the skin, separate from the broad category of race.
Good to know. Counts 5 and 6 are retaliation. And count 7 is disability discrimination for Cagle. They want a jury trial, money damages, front pay, punitive damages, and attorney's fees.
But DHP lays out 8 affirmative defenses in their answer.
Okay, you need to translate some of this legalese for us. They claim plaintiffs failed to state a claim.
Standard boilerplate defense. just saying the allegations don't meet the legal minimum.
What about unclean hands and failure to mitigate damages?
Unclean hands suggest the plaintiffs themselves acted in bad faith, like Cagle walking out of the meeting. Failure to mitigate means if they didn't actively look for other work after being fired or having hours cut, the company shouldn't have to pay all those lost wages.
But the crucial defense is the Farragher-Ellerth defense.
The eighth affirmative defense, yeah.
DHP claims they exercised reasonable care to prevent harassment and that plaintiffs unreasonably failed to take advantage of preventative opportunities. But they literally emailed HR for a confidential meeting and got ambushed. How is that reasonable care?
And that contradiction is the whole case. To use this defense, DHP has to prove they had functioning policies, like the open door policy, and that the employees didn't use them.
But they did use them.
Right. So a federal judge will look at the pleadings to eventually issue a holding on summary judgment. DHP will say, look, we had policies, we had HR. And the plaintiffs will say the policies were a trap.
It's incredible. The complexity of this case is just staggering.
It really is.
I mean, we've got missing wages, language barriers, alleged machine sabotage, and these massive HR missteps all weaving together into this huge federal lawsuit.
Which leaves us with a really provocative final thought.
Yeah.
As the global workforce becomes more diverse, how do legacy HR policies, ones designed for a monolithic single-language workforce, fail spectacularly when placed in a multicultural pressure cooker, like a 12-hour factory shift?
Wow.
Right? Is the legal system even equipped to judge the nuances of cross-cultural communication, or just the paperwork left behind?
That is an amazing point. Well, thank you for joining us for this session of the Employee Survival Guide. Whether you're working a 12-hour shift or managing a corporate office, understanding these legal frameworks is so important.
Absolutely.
Thanks for listening. Stay curious, and we'll catch you on the next one.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to Carey at capclaw.com. That's capclaw.com.